Hi there. So this week at the Canadian Constitution Foundation, we won our historic legal challenge to the Trudeau government's invocation of the Emergencies Act. That was the judicial review at the federal court of the legality of the invocation itself and the constitutionality of the regulations made under that Emergencies Act declaration. The prohibitions on protests and the freezing of bank accounts. Now, our position was that the action by the federal government, which was done in response to the 2022 Freedom Convoy protests, was illegal and unconstitutional. And the federal court agreed with us. Now, this is a massive victory, and today I want to do a deep dive into that decision. Justice Mosley found that the high threshold to invoke the act was not met because there was no national emergency, there was no threat to the security of Canada, as those terms are defined in the legislation, and the regulations violated the charter right to freedom of expression and security against unreasonable search and seizure. And those limits were not justified. Now, the judgment is 190 pages long, and I know many of you are really interested in this case, but maybe you don't have time to sit down and read the whole decision, or maybe you find it difficult to read court decisions. I understand they are often written in technical language. But don't worry, I have read this decision many times now. So I've prepared a list of 10 key passages from the decision that I think all busy but freedom-loving Canadians should know about. I can't wait to tell you all about these key passages. But first, I need your help. The Trudeau government has already said that they are appealing their massive loss. Now, we have a petition telling the Trudeau government not to waste taxpayer dollars, our dollars, appealing their loss. It's at the ccf.ca/defend liberty with us, and I will link to it below. Please sign and share that petition. We really need your help getting this message out that the government should not be appealing a well-reasoned and correct decision. Now let's get to those 10 key passages. So the first key passage I think everyone needs to know about is dealing with the issue that Cabinet was not owed extraordinary deference when interpreting the Act. Now, one of the more galling claims made by the government was that Cabinet is owed near total deference about when an emergency exists. Now, Justice Mosley rejected that proposition by the government, finding that while Cabinet is owed deference because it needs to respond to a fluid situation quickly, there is no untrammeled discretion, and Cabinet is constrained by the objective thresholds written into the statute. So this is at paragraphs 208 and 210 of the decision. It reads, the CCF submits that while Cabinet may be the ultimate decision-making authority, it only has the powers conferred on it by the Constitution, statute, and common law. Earlier cases like Vavilov and Round-Corelli and Duplessis have affirmed that there is no such thing as absolute and untrammeled discretion, and any exercise of discretion must accord with the purposes for which it was given. That was our position, and at paragraph 210, Justice Mosley wrote, I agree with the Canadian Civil Liberties Association and the Canadian Constitution Foundation that the question of whether a Cabinet decision is unconstrained the way urged by the government turns on the statutory text and context of the provisions at issue. The Emergencies Act contains objective legal thresholds that must be satisfied before a proclamation of an emergency may issue. And these thresholds are more akin to the legal determinations courts make, governed by legal authorities, not policy. Thus, while the ultimate decision of whether to invoke the Act is highly discretionary, the determination of whether the objective legal thresholds were met is not and attracts no special deference. The next key passage deals with the finding that there was no national emergency within the meaning of the Emergencies Act. So to invoke the Emergencies Act, there needs to be a national emergency. If the effects of an emergency don't extend to all of Canada, the area where they do extend needs to be specified. And the Trudeau government claimed that the emergency existed throughout Canada, and Justice Mosley called this an overstatement and found that the provinces were able to deal with the situation using existing laws like the Criminal Code. So this is at paragraphs 248 and 253 of the decision. It reads, Section 17 2C of the Act requires that if the effects of the emergency did not extend to the whole of Canada, the area of Canada to which it did extend shall be specified. It goes on to say, the proclamation stated that the emergency exists throughout Canada. This was, in my view, an overstatement of the situation known to the government at the time. And then in paragraph 253, Justice Mosley writes, the majority of the provinces were able to deal with the situation using other federal law, such as the Criminal Code and their own legislation. Now, that last paragraph, paragraph 253, is noteworthy for another reason, and this is my third key passage. It is a restatement of the principle that the Emergencies Act is a tool of last resort. Now, let me read that part of the passage to you. Due to its nature and the broad powers it grants to the federal executive, the Emergencies Act is a tool of last resort. Cabinet cannot invoke the Emergencies Act because it's convenient. It says here GIC, that means cabinet. So cabinet cannot invoke the Emergencies Act because it's convenient or because it may work better than other tools at their disposal or available to the provinces. So this aligns to the testimony of a number of officials during the Public Order Emergencies Commission, who suggested that although the Emergencies Act created useful tools, the situation could have been dealt with using existing law. So, for example, OPP Superintendent Carson Party said, in my humble opinion, we would have reached the same solution with the plan that we had. That was the pre-existing policing plan that ultimately resolved the situation and was developed using criminal code powers. Ontario Deputy Solicitor General Mario Di Tommaso said that it was not necessary. Superintendent Rob Bernier, who oversaw the command center, stated that the powers to compel towing were helpful, but they were not strictly necessary. Ottawa Interim Chief Steve Bell claimed that the legislation helped police create an exclusion zone, but that the police already had a plan to clear the protests. Ottawa Deputy Chief Trish Ferguson said that the Emergencies Act, quote, greased the wheels. And RCMP Commissioner Brenda Lucki shockingly testified that she did not believe that existing tools had been exhausted at the time. So this all affirms the statement of law that the Emergencies Act is a tool of last resort, and it must be more than just useful or helpful. It needs to be absolutely necessary, and all other options need to have been exhausted. Now, the next key passage is the finding that there was no threat to the security of Canada within the meaning of the Act. So Justice Mosley found there was no threat to the security of Canada within the meaning of the Act, and that the term threat to the security of Canada has the same meaning in the Emergencies Act as it does in the CSIS Act. And in the CSIS Act, it requires for the context in which it was applied here, a threat of serious violence against persons or property. Justice Mosley noted that the head of CSIS did not believe that that definition was met, and that the only specific example of threats of serious violence provided were weapons uncovered in coots that were dealt with by the RCMP using the criminal code. So this is at paragraph 259 of the decision. It says, the words threat to the security of Canada do not stand alone in the Act and must be interpreted with reference to the meaning of that term as it is defined in Section 2 of the CSIS Act and incorporated in Section 16 of the Emergencies Act. Then at paragraph 287, Justice Mosley writes, the court cannot rewrite the statute and has to take the definition as it reads. And then at paragraph 288, Justice Mosley writes, while the ultimate decision of whether or not to invoke the Act is highly discretionary, the determination of whether the objective legal threshold were met is not, and attracts no special deference. And this is the important part. There is only room for a single reasonable interpretation of the statutory provision. Now, let's move on to the next key passage, which deals with the finding that economic harm is not part of the threshold to invoke the act. So the government claimed this during the commission, the public inquiry. They claimed economic harm is part of the threshold. They claimed it again at the federal court hearing. And now, following their massive loss, they continue to claim it in press conferences that threat to the security of Canada can include economic harm like damage to supply chain. And this would mean that the Emergencies Act could theoretically be invoked to address labor strikes, which is obviously a troubling proposition. Now, Justice Mosley found that the harm being caused to Canada's economy, trade, and commerce was concerning, but it did not constitute threats or the use of serious violence to persons or property as is required by the legislation. And this is at paragraph 296 of the decision. Justice Mosley writes, the test for declaring a public order emergency under the Emergencies Act requires that each element be satisfied, including the definition imported from the CSIS Act. The harm being caused to Canada's economy, trade, and commerce was very real and concerning, but it did not constitute threats or the use of serious violence to persons or property. And then he goes on to find at paragraph 297, for these reasons, I'm also satisfied that Cabinet did not have reasonable grounds to believe the threat to national security existed within the meaning of the Act, and the decision was ultra vires, which means outside the scope of the government's authority. Now, the next key passage deals with the finding by Justice Mosley of the federal court that the regulations enacted under the Emergencies Act banning attendance at protests violates the Charter Section 2B right to freedom of expression. This was Justice Mosley agreeing with our arguments that the regulations limited the right to freedom of expression by banning anyone attending an assembly that may be, quote, reasonably expected to lead to a breach of the peace, rather than simply prohibiting conduct like blockades. And at paragraph 308, Justice Mosley writes, I agree with the applicants that the scope of the regulations was overbroad insofar as it captured people who simply wanted to join in the protest by standing on Parliament Hill carrying a placard. And then at paragraph 345, Justice Mosley writes, while parked trucks obstructing the roads and blaring horns are not high-value speech, the regulations did not simply prohibit this conduct, which was already illegal under provincial and municipal laws, but criminalize the attendance of every single person at those protests, regardless of their actions. Now, another important finding in this case, our next key passage, deals with the finding that the infringement on freedom of expression was not a reasonable limit. Justice Mosley again agreed with the CCF that the measures that infringed Section 2B freedom of expression couldn't be upheld under Section 1 of the Charter, which allows for reasonable limits where they're demonstrably justified in a free and democratic society. Justice Mosley found that the measures, the prohibition on gatherings, were not minimally impairing in two ways. First, they were applied throughout Canada when they could have been limited just to Ottawa and possibly maybe Alberta. And second, there were less impairing alternatives available that the government was constitutionally required to choose over the measures that they did choose. So this is at paragraph 346 of the decision. I'll read it for you. By applying throughout Canada, the applicants, the CCF, submits that the regulations prohibiting gatherings exposed everyone in the country to their reach. The fact that they were not enforced is inconsequential because they still applied everywhere. The regulations impaired the right to free expression more than was necessary. They captured bystanders who did not agree with the blockades, did not create them, and protested in a non-disruptive way. The regulations also criminalize traveling to a protest where there might have been a blockade, no matter the person's purpose for being there and whether an actual breach of the peace had occurred or not. This, the CCF argues, is not minimally impairing. And then at paragraph 353, Justice Mosley describes his conclusion. The regulations, those are the ones dealing with the protest prohibition, and the economic order, which I'll get to in a minute, that's the freezing of bank accounts. He wrote that they fail the minimal impairment test for two reasons. First, they were applied throughout Canada, and second, there were less impairing available alternatives. The next key passage deals with the freezing of bank accounts, which the court found was a violation against the Section 8 Charter right to be free from unreasonable search and seizure. Justice Mosley agreed with our position that the measures ordering banks to disclose banking information of people who had been designated by the RCMP and to freeze their accounts violated the right to be secure against an unreasonable search and seizure. And the searches weren't reasonable because they required banks to inform the police if they had, quote, any reason to believe someone was materially assisting the protests. Now, a search normally requires that police prove to a third party on an objective standard, like, for example, reasonable suspicion or reasonable grounds to believe that a crime has been committed before the search takes place. So there are relevant paragraphs at 337 and 341, where Justice Mosley writes, the absence of any objective standard was confirmed by Superintendent Baudouin. He acknowledged in cross-examination that the RCMP did not apply a standard of either reasonable grounds or a standard of reasonable suspicion, and all they required was bare belief. And at paragraph 341, Justice Mosley writes, I find that the failure to require that some objective standard be satisfied before the accounts were frozen breached Section 8. The next key passage is the section of the decision where Justice Mosley finds, yes, there was a Section 8 violation of the right to be free from an unreasonable search, and that violation is not justified. So Justice Mosley had found that there was a unreasonable search. And then he also goes on to find that that limit on the right to be free from an unreasonable search cannot be upheld under Section 1 of the Charter, which, as I hope you all know, allows for reasonable limits where justified in a free and democratic society. Justice Mosley wrote that this was because the measures freezing the accounts were not minimally impairing on rights, in part because the governments froze bank accounts of people who had absolutely nothing to do with the protests. Like, they froze the accounts of joint bank account holders, and there was no way for someone who was targeted by the measures to question or appeal the determination. He wrote at paragraph 357, someone who had nothing to do with the protests could find themselves without the means to access necessaries for household or other family purposes while the accounts were suspended. And at paragraph 358, he wrote there was no standard applied to determine whether someone should be the target of the measures or process to allow them to question the determination. As described by Superintendent Baudouin in cross-examination, it was all informal and ad hoc. Now, the last paragraph of the decision, I mean, this is a personal favorite for me because it's kind of a shout out from Justice Mosley to our organization and the work that we did. He noted the value of public interest litigants like the CCF in making submissions and in offering informed legal arguments. He wrote that he had initially actually been leaning towards the view that the decision to invoke the act was reasonable, but he came to the ultimate conclusion he did, that it was unreasonable, and it was after hearing the CCF's arguments. And really, our donors, our supporters, and our lawyers made a really big difference in this case. Effective public interest advocacy matters. This is at paragraph 370 of the decision, where Justice Mosley writes, at the outset of these proceedings, while I had not reached a decision in any of the four applications, I was leaning to the view that the invocation of the Emergencies Act was reasonable. And then he goes on to say at paragraph 371, my preliminary view of the reasonableness of the decision may have prevailed following the hearing due to the excellent advocacy of the government. Had I not taken the time to carefully deliberate about the evidence and submissions, particularly those of the Canadian Constitution Foundation and Canadian Civil Liberties Association, their participation in these proceedings has demonstrated again the value of public interest litigants, especially in presenting informed legal arguments. This case may not have turned out the way it has without their involvement. Like, inject that into my veins, frame it on the wall, put it on my grave. I love this paragraph. Now, I have a document where I've written out all of these key passages with my analysis and commentary. You can go to the ccf.ca and you can read that document yourself. I encourage you to read the full decision. You know, it's very well reasoned, and I think it'll give you some perspective. But of course, if you don't have time, I've tried to help by providing you with these key passages. Now, the government, as I mentioned at the beginning, has said that they are planning to appeal this decision. If you want to help us, you can sign our petition calling on the government not to appeal. If they do still appeal, we are prepared to fight them, but we need your help. Please visit the ccf.ca/donate and consider making a charitable donation to help us. Okay, that's it for today. Thanks for watching, and let's keep fighting for freedom in Canada.